Hi everyone, my name is Michelle Reka,
And my name is Rachel Petron.
and we will be discussing IP protection on a budget.
First, this is a disclaimer for the presentation. This presentation is for informational purposes only and is not to be considered legal advice, nor is it a legal solicitation or advertisement. You should contact your own lawyer to determine what is appropriate for your business.
We will first be discussing how to protect your brand, then how to protect your ideas, and finally how to protect the expression of your ideas.
Our first topic, protecting your brand through trademarks, includes two options. One, to register your trademark, and two, to establish a common law trademark.
For the first option, how do you register a trademark? You will register the mark through the U.S. Patent and Trademark Office, and once your mark is registered, you can mark your logo with the registered trademark symbol. What are the costs of registering a trademark? It costs between $225 and $325 to register your mark electronically, or it costs $375 to register your mark by paper filing. We have also included useful links to both those options below.
Why would you want to register your trademark? You can establish nationwide priority for your trademark if you do so. It is also important to distinguish between an intent to use versus a use application. An intent to use allows you to file an initial application based on an intent to use your mark. A use application actually requires that you use the mark in commerce and then file an allegation of use form to prove it. You must do both of these pieces before the U.S. Patent and Trademark Office will officially register a mark to your company's name. We have also included a link for your reference if you need more information.
Now, for the second option, how do you establish a common law trademark? You create a trademark and use it in your intended geographic area. You should also mark your logo with the trademark symbol. What are the costs for a common law trademark? It is free and there is no registration required with the USPTO. What are the drawbacks of a common law trademark? Your protection is limited to the geographic area where you use your mark in commerce.
Here are a few more helpful links about protecting your brand via a trademark. Most of these resources are available at the U.S. Patent and Trademark Office's website.
Our second topic, protecting your ideas, includes two options. One, to protect by patent, and two, to protect by trade secrets.
First, how do you protect your ideas with a patent? You file a patent application with the U.S. Patent and Trademark Office. Why would you want to do this? Well, it gives you the ability to publicly disclose and use your inventions and technology without losing your ability to enforce the rights of what you created.
What are some of the costs for filing a patent? It will vary depending on the entity's size and type, as well as the size and structure of your patent. Fees are also paid when filing, when the patent is issued, for maintenance fees, plus additional fees. The total cost for a patent application can average around $10,000 to $15,000 for the USPTO fees and attorney fees. We have also included a link to the USPTO website for your reference for more about patent fees.
How do you avoid paying so many fees? You can file a separate application called a provisional application. This is a lower cost option that protects your technology but does not require all the formalities of the formal patent application process. It is important to remember that when you take part in a provisional application, you cannot add new material to this original application if you convert it to a utility application without losing the provisional filing date. So be sure to be as complete and as detailed as possible. These fees range from $65 to $260. For more information on filing a provisional application, we have included a link to the USPTO for your reference.
There are some potential risks with a provisional patent application. It is a temporary solution as it only lasts for 12 months. If you convert a provisional patent into a non-provisional patent, the patent term begins when the provisional patent is filed. This is avoidable, however, if you file a separate non-provisional patent application claiming the benefit of the provisional application.
We've also included some additional links that will be helpful with your patent research.
Now for our second option for protecting your ideas through trade secrets. How do you establish a trade secret? There is no formal procedure, but you must take reasonable steps and precautions to keep your inventions and technologies secret. An example is to use a non-disclosure agreement. And we have also included links to examples of such NDAs for your reference.
How much does it cost to protect a trade secret? It really just depends on how much it costs to keep your secret safe. Why would you want to have a trade secret? Because you can potentially keep your inventions and technology safe forever. Think Coca-Cola. What are the potential risks with a trade secret? Third parties can independently invent your technology. Secrets can also be discovered if they are not reasonably protected.
And moving on to our third topic, protecting your expression of your ideas. This includes two options. One, to establish an unregistered copyright, and two, to register a copyright.
First, in order to create an unregistered copyright, the protection exists from the moment you express your ideas in a tangible writing form. This means when you've painted something, written something, recorded something, that copyright automatically exists. Make sure if you're posting your work anywhere that you mark your work. This is done by using the word copyright or the copyright logo and including the date. This cost is totally and completely free.
For the second option, to register your copyright, how do you do this? You can either file by paper at the U.S. Copyright Office, or you can file electronically at the U.S. Copyright Office. We have also included links to the U.S. Copyright Office for both those options for your reference.
How much does it cost to actually register your copyright? If you file electronically, the basic filing fees are between $35 and $55. If you file by paper, the total is around $85. For more specific information, please see the link above. Why is it important to actually register your copyright if it can just be free? Well, if your copyright is registered, should you be in a lawsuit, you can claim damages and attorney's fees.
We have also included some helpful links regarding copyrights, and these can be found at the above links to the U.S. Copyright Office.
Finally, here is a brief summary of all the different topics that we've covered today to help you protect your technology under trademarks, patents, trade secrets, and copyrights.